Okay, we've just opened up the webinar for attendees to join. So we will get started as scheduled after everyone has had a chance to get logged in to today's presentation on employment terminations in New York. Looks like everything is working properly on our end and people are joining the webinar room. Thank you for attending today. I'm Scott Horton. I will be the speaker for today's webinar. We'll go over a few logistical issues as soon as we are ready to get started. Just want to make sure everyone has a chance to get logged in here. If you're just joining, you hopefully can hear my voice. And if so, I just want to let you know that you should be able to see the cover slide for employment terminations in New York and have access to a chat window where you can type in questions or anything else you would like to say during the webinar. But primarily, we will use that for the questions, and I will answer questions at the end of the presentation. Go over all this again in just a couple of minutes once we have given everyone a chance to get logged in by the scheduled start time. We're going to get started in about 2 minutes. We still have a lot of people who are signing in, so I just want to make sure everyone has a chance to do that before I go over the details, but we will aim for about an hour for today's presentation, and then we will have question and answer at the end. Okay, it looks like everyone who was ready at the start time has probably been able to log in. I'm sure a couple more will add. I'm just going to wait maybe half a minute more and then get started with the presentation. Okay, it is time to get started. Again, I am Scott Horton. I am a partner now with the law firm of Gunnar Cook. Previously, I operated my own law firm, Horton Law. In the past, I have provided these webinars through my firm. At this point in time, I am maintaining my previous Horton Law website to continue my blog and to push out these webinars on a nearly monthly basis. So it has been a couple of months since we put out the last webinar, but that was primarily due to making the transition to a new law firm. But I'm still available to practice labor and employment law. I'm based in the Buffalo, New York area, but Gunnar Cook has an office in Manhattan, and I represent clients throughout the state of New York and sometimes beyond when there are clients that have connections to New York in particular. So today's presentation will be on employment terminations in New York. If you have employees outside of New York, many of the topics we're going to discuss will apply in some respects there as well, but we will be focusing where there are particular laws involved on laws of New York. So for employees elsewhere, you might want to consider whether there are similar state or local laws in those areas. We will go for about an hour. I will do a question and answer at the end. If you have any questions, you can type it into chat. I will most likely wait until the end to do the Q&A, but if there's a question that I happen to see and I can work in the answer as we go, then I will try to do that as well. If you are here looking for HRCI credit, you will get an email tomorrow with the approved provider number for this webinar, and you will get 1 hour of credit. If you are looking for the slides for today's presentation, they will be available at the end for you to download today, or again, you will get an email that will have the link to those. So when we are talking about the termination of employment, there are many terms that get thrown out: firing, laying off, separating, terminating, discharge, dismissal. You've heard most or probably all of these terms, and they're not necessarily perfectly defined. So some people use layoff to mean specifically a financial separation of one or more employees for business reasons, but others use layoff to mean a situation where employees are temporarily put out of work with the expectation that they will be brought back to work. Where relevant for today's presentation, I will try to comment on what I'm referring to specifically, but much of what we're going to talk about today would apply to any form of employment separation, or at least potentially could apply. But most of the legal risks, of course, are going to be related to involuntary terminations, where the employer decides that they no longer wish to employ one or more particular individuals. So there's a broad array of involuntary terminations. And then on the flip side of it, you have resignation, retirement, quitting, whatever you want to call it, that employees do as well. For the most part, we're not as worried about the legal issues there, but there are a couple of things that you will see where those do become important legal considerations. So let's start with the issue of at-will employment. New York, like almost all of the states in the United States, all except Montana, I believe, is an at-will employment state. What does at-will employment mean? It means that either party to the employment relationship may end it at any time with or without notice for any reason or no reason at all. Legally, that is technically the default in New York State, at least in the private sector. In the public sector, by which I mean government employers, the state or local government entities, and certain public authorities, there are other statutory exceptions to the pure concept of at-will employment. But even in the private sector, you see here that I caution to essentially assume that at-will employment is a myth. In other words, if you're an employer and you are going to let an at-will employee go, be very cautious about especially the very last point on this slide, that is taking such action for apparently no reason at all. Because of all the limitations that we're going to talk about in the subsequent slides, employers should have some reason for taking the action of terminating an employee's employment, and preferably a good business reason. Even where it does apply, generally, at will employment is subject to limitations. And that comes through both legal, contractual, and other sources. The most common consideration when you are involuntarily terminating an employee, really throughout the United States, but certainly in New York as well, is whether there could be a claim raised under one of the various employment discrimination laws. So we'll talk about that in a couple of minutes. The issue I raised before is that if you are a public employer, so a town, a county, a city, a school district, or a public authority operating in New York, then there are likely going to be statutory or other limitations on when and how you can impose discipline on at least some of your employees. In any case, it may be possible to have a written employment agreement, which could be with one individual employee, or a collective bargaining agreement, which normally would only arise if you have employees who are unionized, in which case you would negotiate with that union to set the terms and conditions of employment, often including the provisions surrounding disciplinary and termination rights and procedures. That gets memorialized usually in a collective bargaining agreement. Then, separate and apart from formal agreements between employees and their employers, you may have company policies that create at least apparent limitations on the employer's right to discipline. In some cases, apparent limitations on the employee's right to resign as well. We'll talk about those briefly in a couple of spots in the presentation. Finally, I note on here local laws. New York City currently has statutory or through local ordinance just cause protection for certain fast food workers. So some fast food workers within the confines of New York City can only be terminated from employment upon a showing of just cause. That is an exception right now, both for New York City and throughout New York State, and again, generally throughout the United States. However, New York City and New York State both have proposed legislation that would end employment at will, either throughout New York City or throughout New York State. There's no guarantee that that legislation will pass, and it may be more likely that there will be some sort of limited scope. Again, New York City first did it with fast food workers. There may be other industries that will be addressed before there's some sort of widespread elimination of at-will employment. But there is legislation out there at both the state and New York City levels. And certainly if that legislation were to be enacted, especially as broadly as it's currently proposed, that would be huge news, and we would likely be doing a new webinar to tell you about that as quickly as possible. So again, I mentioned the discrimination laws. We're not going to spend too much time on this. It's pretty common if you're working in human resources or otherwise have experience working with terminations and thinking about the potential pitfalls to consider, is this likely to result in a discrimination claim? I've listed some of the various federal and state employment discrimination laws here. In New York State, we have the New York State Human Rights Law. In New York City, there's also a New York City Human Rights Law. So within New York City, employees might be able to claim the same type of discrimination under city, state, and federal law and have a choice of 3 different agencies with which to make that claim, in addition to potentially going directly to court. The bottom line is, even where more than one of these laws apply, the more local law tends to be most protective. So in New York City, the New York City human rights law tends to be more protective than both the state law and the federal laws. In New York State, outside of New York City, the New York State human rights law tends to provide more protections than the federal laws. But many employers are subject to all of these laws and would need to comply with any and all of them. What does that mean in the termination context? It means, at bare minimum, that no employer can intentionally terminate an employee on the basis of one of these protected reasons, or at least in most cases could not. You're probably familiar with many of the protected characteristics. I've listed here the New York State human rights law protections. Many of these are also protected by federal law: age, race, creed, color, national origin, sexual orientation, sex, disability. For example, some of the others are only covered at the state or potentially New York City level, including gender identity or expression, citizenship, immigration status, arrest and conviction record, familial status, marital status, status as a victim of domestic violence. There's some overlap among these different categories, but the bottom line is, if there's any chance that you are deliberately making a disciplinary, including termination decision based on any of these factors inherent to an employee, or one that may raise the appearance of being discriminatory on one of these factors, that would warrant some consideration in your approach. Obviously, if you're doing it for that reason, that's illegal. If you're not doing it for that reason, but think that the employee might nonetheless perceive that the action is taken for a discriminatory reason, that might affect how you handle the termination in some ways that we will yet discuss. Here is a list of New York City protected characteristics. As I mentioned before, if anything, New York City tends to protect more even than New York State. For example, the protected characteristics in New York City currently include credit history and refer to some of the other statuses using different words. But the main reason I wanted to put this slide out here is that relatively recently, New York City has adopted anti-discrimination provisions regarding height and weight. So effective November 22nd, 2023, employers in New York City will no longer be able to make employment decisions based on height and weight. In the rare exception of a situation where someone's height is a bona fide criteria for the position. For example, if you're a professional basketball team in New York City, perhaps you would be able to use height as a factor in determining which players you're going to sign. But in most jobs, height and weight will be off limits as considerations, both in hiring and in firing, among other aspects of the employment relationship. That is a new characteristic for New York City that is not yet protected statewide. However, the trend recently has been for the state to adopt New York City expansion. So it's quite possible that by November, or at some point in the relatively near future, height and weight will become protected characteristics throughout New York State. At the state levels, only Michigan has anti-employment discrimination protections for height and weight, and there are a few other cities scattered across the United States that already have that, but it is a pretty new area for these types of protections. Relatively briefly, I'm going to comment on a couple of the laws that apply to public employers in New York State, or may apply to them. Most of you are in private business, and these would not pertain, but just to give you an idea of what some of the statutory alternatives to at-will employment look like. And for those of you who are public employers, I want to make a couple of notes. First, many public employees are subject to the civil service law and Section 75 of the New York State Civil Service Law. This is the default provision for many government employees that says that they can only be terminated for incompetence or misconduct if the employer follows certain procedures, which includes written charges of the basis for the employer feeling that the employee has been incompetent or engaged in misconduct. At the employee's request, there could then be a hearing over the charges with a final determination, which currently is made by the employer, with the potential then for appeals into the court by an employee who doesn't agree with the employer decision. One reason I brought this up now as well is for those of you who are in the public sector and you are subject to Section 75 for some of your employees. The New York State Legislature literally this past weekend has passed amendment to Section 75, which will make this a significantly more burdensome process for employers, including giving the authority to make the final decision to a hearing officer that will now have to be mutually selected between the employer and the employee or union, if applicable. So the governor has not yet received or signed that legislation, but there's reason to suspect that she will. So if you have Section 75 eligible employees now, make sure you are aware of that legislation. In fact, if you are a school district, you're already familiar with what Section 75 is about to be amended to require. This is generally applicable to teachers and administrators who are certified by the State Department of Education. So again, it doesn't apply to most of you, but for those that it does apply, or if you're wondering about the teacher protections, you've heard of their tenure rights. Once a teacher or administrator has tenure in a school district, they can only be removed for just cause. This law requires that charges be filed. The school board determine there is probable cause to believe that these charges are valid, and then ultimately a hearing before a mutually selected hearing officer who issues the decision that is binding, subject to appeal again into the court. This has for many years been more restrictive than what's available to most non-teachers in the government service in New York. But with the amendment to Section 75, the two procedures will look much more alike. Now, again, one of the reasons I'm pointing out these statutory protections in the private sector is to note that if we were to somehow in New York City or throughout the state lose the at-will employment regime, then the legislation would impose some form of just cause requirement. In other words, employers would have to be able to prove that they had just cause, however that's defined to mean. And then there may or may not be specific hearing provisions that are applicable, or whether there's a hearing before going into court, or employees only have the right to appeal directly into court. The decision by their employer are questions that would depend on what that legislation ultimately includes. So while we're still in the at-will world, employers and their employees can agree contractually to limitations. Some employment contracts specifically preserve at-will employment. Others impose limitations on terminating an employee, such as for cause. or just cause in some cases. And there are sometimes references to good reason. Sometimes for cause or just cause are defined to mean one thing, and good reason or similar wording is defined to mean something else. Usually, these different terms are defined in some length, hopefully with some degree of clarity, and they're more often than not never going to require an employer to continue to let someone work for them longer than they want to, and never going to require an employee to perform services for an employer longer than they want to, which would be unconstitutional anyway. But they will spell out the ramifications of not having cause or reason or whatever the other stat or contractual terms are. So often there will be provisions relating to notice, saying that to qualify as for cause or for good reason or what have you, either there does or doesn't have to be a certain notice period. And then, there are various other consequences of these different designations. For example, is the employee going to still be paid out for some period of time? Is that going to include severance pay? Is that severance pay going to include bonus payments that the employee might have earned? Again, the parties are pretty free to contractually agree to what these parameters are. Just last note, employment contracts, separate and apart from terminating for cause or for good reason, often have terms. So it might be a 1-year employment contract or a multi-year employment contract. And sometimes there are provisions around what has to happen for it to be renewed for some period of time. The biggest caution for employers is just because your employment contract has a term that's coming up, it doesn't mean that you can let an employee go for an otherwise illegal reason. So failure to renew a contract or terminating an employment contract for a discriminatory reason is still going to be potentially problematic if the employee makes a discrimination claim. In the union context, you're likely to have a negotiated collective bargaining agreement. So, of course, if you're ever going to discipline or terminate an employee in that setting, you want to know if there's a relevant negotiated rule or provision. And then, if so, what does that require? And again, this could theoretically be whatever the parties have come up with and agreed to in writing. Even without a collective bargaining agreement, either whether you're unionized or not, employers obviously adopt policies. This could be, for example, a different non-disciplinary policy like sexual harassment that nonetheless provides that if you violate this provision, you're going to receive discipline. So that's always relevant if that is the case. But there are also policies that could be put in place that address disciplinary procedures. For example, many employers have references to progressive discipline in their handbooks or policy manuals, even though there's not necessarily any sort of legal obligation to have that. But once you put that in place, or if you suggest there's going to be meetings before final decisions are made, or there's going to be the opportunity to file some sort of complaint or grievance internally, then most employers should be following those procedures. However, it is possible that you could decide not to in a given circumstance. Usually your employee handbooks are going to be clear that they're not contractual, and the employer has the right to change them or deviate from them. But of course, anytime you do something like that, you again create the potential risk of some sort of discrimination claim if the employee can say, I was treated differently because of one of the myriad protected characteristics. When all else fails, whether in the union context or not, any past practice or previous approach to similar situations can be either used to support the employer's decision or used to support the employee's claim that they were somehow wrongfully terminated. Past practice in the union context could be a specific term that means that something has happened a certain way sufficiently often that even though it's not written into the union contract, the employer is still obligated to continue to follow that practice. That same concept is not necessarily true in the non-union context and may even be challenged in the union context in certain circumstances. But again, if suddenly you've always done something a certain way but treated this employee different by terminating them without prior notices, for example, that could be pointed to as evidence as discrimination. In the union context, there's almost always a negotiated grievance procedure that often ends with the possibility of binding arbitration. So this means that if the employer terminates an employee's employment, the employee could grieve it, often saying that there wasn't just cause for the termination, as these contracts typically require. And then there's a certain number of steps that the grievance can take with internal review and often denials up to the point where if the employer ultimately upholds the decision and the employee and union still don't like it, they can go to a private neutral arbitrator, either one that's pre-selected in the contract or one that is mutually selected between the parties by some agreed upon procedure. Once the arbitrator takes the case and hears the case and issues a decision saying the termination is either upheld or reversed in some way, then that decision is final, subject only to pretty deferential review in the courts if you could show that the arbitrator was clearly biased or made some really egregious mistake. This can also be a component of employment contracts or potentially even employer policy. But again, it's most commonly found first in collective bargaining agreements and then sometimes in employment contracts. I've added a slide in here on performance improvement plans and last chance agreement. These are not specifically an exception or alternative to at-will employment generally applicable to your workforce, but these are documents that are sometimes put in place for specific employees under circumstances that may have warranted ending someone's employment, but for whatever reason, the company is not quite ready to do that. Sometimes this is because they really think that the employee just needs better corrective parameters so that they can figure out how to do the job properly. Other times the employee is really messed up and maybe there's a union involved and maybe they've grieved it and everybody has agreed versus going to arbitration to give the employee another opportunity to see if they can do better. So I say that often these types of approaches are alternatives to termination, but it's not that unfair to look at them as, in essence, almost precursors to termination as well. In many cases, when performance improvement plans or last chance agreements are used, there's probably some expectation that this may not work out. Where do we see these types of documents? Really can relate to any misconduct or performance types of issues. Obviously, performance improvement plan is designed to specifically tell the employee these are things you're not doing the way we'd like them done. Often there's some time period by which we're going to monitor and review performance going forward. And then if expectations still aren't met, then likely the employee will be let go. Misconduct could also be addressed through performance improvement plans, especially if you're talking about misconduct in the area of attendance, for example, or perhaps just carelessness. So there doesn't, in this situation, have to be a clear delineation between what's misconduct and what's performance. But when we're looking at a last chance agreement, again, these are just generic names. You could title a document whatever you want typically. But a last chance agreement is generally the concept of employee has done something wrong and we're going to let you stay on with the written agreement that if you do this again, you're going to immediately lose your job. You could put all sorts of other conditions in there, which we see commonly for drug and alcohol issues. So employees who have appeared at work under the influence or perhaps even been caught in possession of something inappropriate at work or what have you, might be subject to a last chance agreement that involves them taking a referral to a employee assistance program and potentially seeking some sort of counseling or rehabilitation as a condition of continued employment. All these things are potentially available, whether in the union or non-union context. If there's a union involved, it would typically have to be negotiated with the union if there's not some established practice of doing them. But again, these are not legally required independent of employer agreements and policies. And the last caveat on this is even if you have some sort of performance improvement plan or last chance agreement or what have you in place and the employee failed to live up to it and they are then let go, that does not conclusively mean that they can't still file a discrimination claim or somehow otherwise contest their termination. But it would typically, if done properly, be some evidence, hopefully in favor of the employer's action. So when you have an employee whose employment comes to an end, there is the potential that the employee will get unemployment. New York's unemployment system is relatively complex in some situations. I'm not going to go into every detail here, but I want to hit some of the highlights because many employers do have these thoughts and questions when they are deciding whether to let particular employees or even groups of employees go. Unemployment essentially is an employer-paid employee benefit. Most employers pay in through essentially a tax withholding to the state unemployment system, and that rate that the employer pays in is based on their utilization, at least in part. Everybody's going to pay something, but the number of unemployment claims that a particular employer has over a period of time will affect how much they are contributing on, like a per employee or per income basis. Some employers, probably mostly limited to the nonprofit world, pay dollar for dollar for unemployment claims rather than based on essentially the insurance rating type of process. But either way, the more employees you have going out and getting unemployment benefits, the more it is going to cost your business. So there are pros and cons of challenging individual unemployment claims. Obviously, the most direct pro for doing it is that you reduce your potential costs if you can avoid unemployment claims that are not valid. The biggest downside to challenging unemployment is that some employees who are denied unemployment may then become more motivated to seek other claims against your company. Sometimes letting someone get unemployment is a reasonable compromise to the risk that challenging it would make the employee more aggressive and looking to sort of get payback in other ways, which might include, for example, filing a discrimination claim. There's also the aspect of someone who's been denied unemployment and not able to find other work, just becoming more desperate and thinking the only way they might be able to support themselves is if they can get some sort of discrimination claim to either settle or to win a verdict against your company. I want to note here too that the allocation of unemployment charges gets complicated when the same employee has had multiple employers in relevant time periods. Couple of different ways this applies. So in determining how much unemployment an individual employee it might be eligible for, even assuming they're otherwise eligible for unemployment, the state is going to look at how much money they earned through employment over a certain time period. I'm not going to get into the exact determination of those time periods, but then if the employees had multiple employers within that time period, there could be an allocation of the charges between those different employers. One thing that tends to really surprise employers who haven't seen this is the situation where an employee works for you and then resigns to go take another job, then loses that new job due to some circumstance entirely beyond your control. Maybe that employer just needs to lay people off. Then the employee goes and gets unemployment. Depending on the time periods involved, your company could still get charged with some and potentially a relatively large percentage of the unemployment benefits paid out to that employee, even though they voluntarily quit working for you because their last employment was lost due to a non-disqualifying reason, and the allocation rules still apply in that scenario. So what will disqualify someone from unemployment? Generally, voluntarily quitting from their most recent employer will be disqualifying. Refusing to accept suitable alternative employment is a disqualifying circumstance, but there's some room to argue what suitable alternative employment is. If the employee is otherwise no longer available to work, for example, they've gone back to school in some cases or has some medical issue that prevents them from working, or potentially if it's a position that requires licensure and they've lost that licensure, that might be an example of where they're no longer available to work in suitable employment. There's particular provisions for employees who go out on strike. They're not working, then they're not eligible to get unemployment for 7 weeks at least. But the biggest area of interest for employers is the misconduct question, because employees who are involuntarily terminated for misconduct, as that is defined by the unemployment law, can also be denied unemployment benefits, which again would help keep your unemployment costs down. How do employers in New York prove this type of misconduct, which again is not necessarily the same as the proof of misconduct under Section 75 of the New York Civil Service Law or anyone else's general understanding of what misconduct is? There are really two things that the unemployment system considers misconduct. One is a situation where the employee had clear prior notice that engaging in a certain behavior would result in their termination. And the other is, okay, even if there wasn't such clear prior notice, the employee's conduct was so bad that it was illegal or clearly unacceptable and likely to result in termination of employment. I generally find the second category to require some relatively extreme behavior in these categories. Most criminal acts are likely to qualify. And then these other categories are probably going to also be criminal acts, but even where there's not necessarily any criminal prosecution, or maybe there's not quite the level of criminal intent that would be necessary under the penal law. But falsifying material documents, consistently falsifying reimbursement submissions or time records, for example, which may also qualify as theft as well. Falsifying whether you cleaned the bathroom like you were supposed to at 2:00 in the afternoon might not alone be sufficiently material to justify a finding of misconduct under the unemployment system. In that sort of case, it would probably be better to put someone on specific notice that you're expected to do this as a condition of your job. And if you don't, both actually clean the restroom and indicate on the schedule that you have done it as you were supposed to, then you are going to lose your job. In which case, if they continue to not do it and you fire them, then in that case, you could probably claim and show misconduct. And of course, physically violent behavior in the workplace generally isn't going to be acceptable and often is going to result in the denial of unemployment benefits, even if you haven't specifically already warned the person not to hit their coworkers. Here's a quick overview of the unemployment process for those of you who haven't gotten too deeply involved with it. First, of course, it's not going to get triggered until the employee or former employee goes and seeks unemployment benefits. Then the state will send the employer documentation asking for information. This is basically first to confirm the right amounts of income for the employee over the relevant time period, and to ask the employer if it's aware of any circumstances that might warrant the denial of unemployment. Based on whatever information it receives, the Department of Labor makes an initial determination, either granting or denying unemployment. And then it's possible for either the employee or the employer to request a hearing to challenge that determination. If that hearing occurs, it will be before an administrative law judge who will then render a decision. That decision can be appealed to the Unemployment Insurance Appeal Board, which issues the state's final determination on the unemployment claim, though that, like most other agency determinations, could be challenged into the courts. In this case, if you're challenging an unemployment appeal board determination, you have to challenge it in the appellate division, 3rd department, which is the court that has appellate jurisdiction over Albany and the surrounding area. So even if you're in New York City or Buffalo, for example, you would ultimately have to be in court in Albany. Okay, moving on from unemployment benefits, there's another circumstance where employees sometimes get money for, in essence, losing their job, and that is through severance payments, which are normally pursuant to a severance agreement. Some companies will have severance policies in place that says if you lose your job, you do get a certain amount of severance pay. Often the severance pay is something that the company just decides to offer after the fact in a particular circumstance. And in either case, the money can be paid voluntarily without any sort of written agreement, or there can be a written agreement, which usually includes the employee releasing potential claims against the company in exchange for receiving some amount of severance pay. If you're going to do that, we recommend having the severance agreement in writing. using an explanatory cover letter that's not entirely legalistic, that tells the employee, okay, here's what's in the severance agreement. You're going to get this, you're going to get this, and in exchange, you're going to agree to this. You can use these to address any outstanding agreements, like clarifications on any disputed commissions or bonuses owed, or return of company property, or really it could be whatever makes sense under the circumstances, obviously assuming it's something that's legal. You should always be allowing the employee time to review these if they're giving up any rights, including waiving claims. And this means some number of days usually, rather than take it or leave it, in which case if they did sign it on a take it or leave it basis, at the moment of termination, the release they sign may not be enforceable down the road. You should expect the employee to take the agreement and review it with an attorney, in the sense that you want to make sure it's written in such a way that you'd be okay if they did have it reviewed by attorney. Of course, the reality is many and probably most employees aren't actually going to retain an attorney, but some of them will, and you won't always be able to predict which ones those are. Finally, regarding severance agreements, there's something called the Older Worker Benefit Protection Act. This is an amendment to the Federal Age Discrimination and Employment Act, and basically sets forth certain requirements for having an enforceable release of federal age discrimination claims. Many employers just follow its requirements for all employment-based releases, just because it's the only statutory guidance generally about what such releases should include, but you don't necessarily have to meet all those requirements, except when you have an employee who's over 40 and you want to have the effective waiver of ADEA claims. I'll identify those requirements in a moment. Just want to throw this kind of update in now. Relatively recently, going back a couple of years, there have been increasing limits on what severance and settlement agreements can say as far as confidentiality, meaning if you try to put in a provision that says the employee can't discuss the facts related to actual or potential discrimination claims, that may not be acceptable. In some cases, it's only acceptable now where the employee has essentially preferred to have confidentiality over those issues. That being said, even more recently, in the past couple of months, the National Labor Relations Board, which is a federal agency that has authority over, in some respects, most private workplaces throughout the United States, has objected to any confidentiality or non-disparagement types of provisions in severance agreements. Following a decision by the National Labor Relations Board, the General Counsel of the National Labor Relations Board came out and issued guidance that went so far as to say even offering an employee a severance agreement that has a confidentiality provision in it could be an unlawful act, whether the employee accepts and signs off on the agreement or not. She went on to suggest that employers that have severance agreements already in place with former employees that include confidentiality or non-disparagement types of provisions actually contact those individuals and let them know that they're no longer going to be held to those commitments, and suggesting that if employers don't do that and there's for some reason a challenge against the company for having issued that severance agreement even before these decisions came down, that could be a violation of the National Labor Relations Act. Talk to your legal counsel before going quite to that extreme, I would suggest, but going forward, there is increasingly reason to not include too many restrictive aspects in your severance agreement, And I think so far, at least, it's still pretty well understood that what you can get in exchange for paying severance is a release of claims against the company. And that's usually the primary goal of these types of agreements. Again, either as a best practice or because you need to maintain the enforceability of the release against federal age claims. Here's the Older Worker Benefit Protection Act requirements. Needs to be a written agreement calculated to be understood by the employee. So it's going to have some level of legal terms and requirement, but in theory, whoever that particular employee is should be capable of understanding what they're signing off on. Again, if we're trying to waive rights under the ADEA, that needs to be specifically spelled out in the document. There can be no prospective waiver, which is generally accepted as the case for employment law claims. So you're having the employee waive claims up to the point in time that they sign the severance agreement, which is usually a good reason to not let an employee sign the severance agreement until after their employment has conclusively come to an end. The employee has to receive something of additional value. Usually this is some sort of severance pay or benefits like healthcare continuation. Nothing specific that has to be required or any certain value that has to be required, but it can't just be that they're going to receive their final paycheck, which is money that they've already earned and they're already entitled to. The key numerical requirements of the Older Workers Benefit Protection Act that many people are somewhat familiar with, but may not entirely know what they require, are that you have to give the employee at least 21 days to consider the agreement. So again, I never recommend a take it or leave it, but in some cases you could, expect the employee to get back to you relatively soon. To have it enforceable under the ADEA, you would have to give the employee at least 21 days to sign. However, if they sign before the end of the 21 days, that's okay. The non-revocable provision is that once the employee does sign, they have to have 7 days to revoke. So they can't agree that I've signed this and now this is going to take effect even before 7 days are up, because they have to have that 7 days to potentially change their mind completely and revoke the agreement. I don't remember if I've ever had someone actually revoke an agreement, but normally you want to make sure that you're not paying out any of the severance benefits until more than 7 days have elapsed since the employee signed, because you don't want to be in a complicated situation where the employee has already been paid severance and then revokes the agreement and tries to sue you. Now, there are additional requirements for group terminations, and this is where it starts to get a little tricky. Most of the requirements are the same, but when you have a group termination program, you then have to allow not only 21 days, but 45 days for each employee to consider whether they're going to accept the agreement. There's still the 7-day revocation period, but there are also additional notice requirements. You have to provide the employees lists of ages of employees by positions, which I'll show you in a moment. But the idea is, let's say you're letting go all of your accountant ones and keeping your accountant twos. So you would probably need to list all of the ages of the accountant ones who are being let go and the ages of the accountant twos who are being retained. Or obviously, if you're keeping half your accountant ones and half your accountant twos, you'd have the respective lists of ages of which ones are being kept and let go. Obviously, the idea of this is to show these employees the data to decide, well, it certainly looks like they're keeping all of the younger employees and getting rid of the older ones. Whether that's the case or whether there's otherwise legitimate business reason for that approach is, a separate issue. You also have to have some form of program description that's actually a written description of why certain employees are being considered for participation in this termination program. Again, if you're in this situation, you should discuss it with your labor counsel, but the idea being that whenever you have more than one employee who's being let go simultaneously or close in time for the same or similar reason, that's not, individual misconduct type of instance. So, we're downsizing usually in one shape or form and offering a severance agreement that's going to have a release of ADA claims. These are provisions you should be paying attention to. Just by example, here's what the age lists kind of look like, different ways you can do it, but you do have to give the employees this data within some framework. Usually it's not all the employees in the organization, it might be on a department basis or what have you. And that's where the program description is going to have to specify which subset of the total employees of the company were under consideration in the first place. The next topic I want to just provide some information on without too much discussion is the WARN Acts. There's a New York State WARN Act and there's a federal WARN Act, and a number of other states have WARN Acts. Since we're talking about New York, I'll mention our neighbor New Jersey, which has a WARN Act that now has recently been amended to potentially require not only notice, but also actual severance pay. Again, New York does not require any severance pay in any circumstances, except that if you don't provide notice where you're supposed to under the WARN Acts, then you can be subject to penalties, which would start to look like severance pay because it basically is based on how much the employee would have received in pay and benefits for the days on which they didn't receive notice that they should have under the law. The New York law is broader than the federal law, but you could be subject to both. It applies to sufficiently large business enterprises, which typically only means private employers. It would be rare that any public governmental entities would be subject to this. So if you're a public employer, you're probably not worried about WARN issues. If you're a private employer, then the question is, how big are you? If you have 100 or more employees in the US, you could be subject to the federal WARN Act. If you have 50 or more employees in New York, you could be subject to the New York WARN Act. The law requires notice in advance of certain actions, which include a plant closing. So you're shutting down a work site entirely under New York law. If that happens, and at least 25 non-part-time employees are going to lose their job during a 30-day period, then the WARN obligations may be triggered. The threshold is 50 under the Federal WARN Act. For mass layoffs, so this is a situation where you're reducing your workforce in relatively large numbers, but not entirely closing the facility. So here would either have to be at least 250 employees in New York or 500 in for the Federal WARN Act, or the lesser number of between 25 and 249 employees in New York if it constitutes at least 33% of the active workforce at that location. So again, if you're anywhere close to these, you want to look more carefully at what the obligations are. I just want to make sure you have the general numbers. If you shut down a work site that has 8 employees, or you lay off 9 employees at a location, then you're not likely to trigger any obligations here. But if it's close to that 25 number in New York, you want to at least look more carefully. There's also a provision on relocation, which just says if you're moving your operations or a substantial portion of your operations at least 50 miles away for 25 or more employees, then you also have to give notice. Although it's plausible that that would also qualify as a plant closing or mass layoff as applicable. You have to give 60 days notice under the Federal WARN Act, but New York State requires 90 days notice. As I mentioned, there are penalties for not giving notice, and there are some exceptions. I can go into too much detail on the exceptions, but I got another note on that in just a moment. Just want to also clarify that I've said 30 days and how many people are losing their job within 30 days. That technically what the law says, but then there's another provision that really makes it mean 90 days in a lot of cases. So where, there's a series of rolling layoffs that are all related to the same downsizing plan, for example, basically you have to look at the total number over 90 days. If you can say, well, these layoffs in this 30 days are entirely based on this one cause, and then 60 days after that or 50 days after that there's some more people that lose their job due to another cause, then you might not have to aggregate those. But again, really, to first identify whether you might have a WARN issue, look at 90-day windows and then see if you can narrow that down. Notice has to go to the affected employees, including part-time employees, even though part-time employees don't count in the numbers to trigger the notice. If employees are unionized, notice has to go to the unions. And there's also a number of government officials who have to receive the notice, especially under New York law, which has recently been amended to require notice to even more government officials. Other New York State WARN updates. In April, I believe it was, New York State launched a new online notice portal, which is designed, I guess, to streamline completing the notice requirements, at least to the government agencies. So if you have to give these notices, there's a new way to do it. And there are pending new regulations from the New York State Department of Labor that, in summary, basically create more burdens for employers, providing that every affected employee's contact information and pay status be provided to the New York State Department of Labor, and that employees be provided additional information regarding any severance and dislocated worker assistance. And the biggest thing I mentioned, there's some exceptions to whether you have to give notice or not, even if the numbers are triggered. The new regulations seem to suggest that in order for an employer to rely on one of those exceptions, they would have to actually file a request with the New York State Department of Labor to invoke one of those exceptions, which has never been a requirement under the New York State or Federal WARN Act in the past, but it may be if these regulations are adopted and enforced. Just one or two quick points. If you have any questions and haven't entered them yet, go ahead and do that. We'll be answering questions in just a minute. I just want to conclude by noting that New York does have a requirement, statutory in the labor law, for private employers that they must provide written notice to any discharged employees stating the effective date of termination and the exact date that any employee benefits, such as health, accident, and life insurance, will cease. This notice has to be given out within 5 working days after the date of termination. And notably, this requirement applies independent of any of those notice considerations under the WARN Act. This is just a general, any employee whose employment comes to an end, whether they've resigned, retired, or been terminated, the employer is expected to notify the employee of the effective date of their separation. This is also separate from things like the COBRA requirements, where you may have to be giving separate notice to employees of their eligibility to continue their health insurance. But what you should be doing in this document is saying all benefits end, if that's the case, as of the effective date of employment or whatever the date is. And often this first notice will say you will be receiving separate documentation regarding your COBRA rights. And I think my last point is once you do terminate an employee in the private sector, New York labor law requires that employers issue the final paycheck by the next regularly scheduled payday after separation. If any of you think that's too burdensome, go to California, where typically the requirement is that employees have to get their final paycheck on the date of termination, independent of the payroll schedule. Unused leave time, PTO, sick leave, vacation, etc., doesn't have to be paid out by law, but if your policy on those benefits doesn't specifically say that it won't be paid out, then you would have to pay it out. Or if it does say you will pay it out, then you have to pay it out again by the final paycheck or with the final paycheck or by the next regularly scheduled pay date after separation. And when an employee has commissions and bonuses as a component of their compensation, it might not always have to be paid out by that next pay date, but it will depend on when and whether those commissions and bonuses are earned by the terms of any commission and bonus plans. Sometimes those plans say the employee has to remain employed through the date that the payment would be made in order to earn it. Sometimes they, say that the bonus is not going to be paid until, the end of the year or something like that. And depending on the wording, that might excuse you from immediate payment, but those are issues to, again, carefully review if applicable. All right, I apologize. We went a few minutes over our hour, but I will stay and answer whatever questions you have for any of those who have time to stay. For that, I'm going to now give you the link to the slides for the presentation. For those of you who want that, but again, you will get an email tomorrow that will give you a link to download those as well. So you'll have that if you don't want to do it now. If you have any more questions, go ahead and enter them, and I will get started answering the questions that you have. Just note that I'm going to answer the questions to the best of my ability based on the information you provide. But if your situation is very detailed, be cautious because there's not attorney-client privilege in this forum, so don't provide anything that you want to keep confidential. I have a question that says, if you have an employment agreement with a start date and end, can you terminate for performance or other behavioral reasons? It really depends on the contract. Once you create an employment agreement, you are going to be expected generally to abide by the terms of that employment agreement. Obviously, not all agreements are as careful as others to spell out every possible scenario that might realistically occur. But if you are going to have an employment agreement for a specified period of time, you should also have in there either a specific statement of at-will employment or whatever alternative criteria the parties agree to for either side separating employment. Again, I note that the employer is never going to be able to force an employee to continue working for them. These contracts may say you have to provide 2 weeks notice or 4 weeks notice, and theoretically there could be some sort of monetary penalty for not giving that notice, but you're not going to be able to get a court to compel someone to work for you. The 13th Amendment to the U.S. Constitution took care of that, outlawing things like slavery and indentured servitude. Going the other way, they're not as likely, but somewhat possible that a court could compel an employer to continue to employ someone. And this happens relatively frequently in the union context with arbitration decisions where employees are discharged and then found not to have had just cause, in which case the arbitrator can order and often will order the employer to reinstate the employee. Is there a statute of limitations on revoking of severance or the employee rights to sue after the fact? I'm not entirely sure I understand that. Again, whatever your agreement says is generally going to apply as long as it's legal. If you do put in that revocation period of 7 days, then you have obviously to wait the 7 days and the employee could revoke it. Otherwise, if you don't have that in or something alternative along those lines, the default would be once the agreement is signed, it's enforceable if there's a valid release of claims in there and the employee signs it and then the next day goes to try to sue inconsistent with the release. The employer could try to defend against the suit by pointing to the release. And in those cases, really, whenever you're trying to enforce such a release, it's going to be a totality of the circumstances type of review by the court. And of course, whatever claims the employee is bringing probably have statutes of limitations. So all of that would work together. But if you don't have anything specifically in there, the default assumption would be that once it's signed, it's valid and hopefully enforceable. I have a question that says that if an employee is under a probationary period and are terminated due to their performance, do they also require multiple write-ups and warnings before termination? I mean, again, there's no absolutes here. You could put whatever you want into a policy or agreement. Normally, probationary periods say that, you know, you'll be reviewed at the end of a certain period of time, or it may be that you otherwise have a progressive disciplinary policy and you say that during the probationary period, you know, you're subject to being removed without regard to progressive discipline. But again, if you're not unionized, you don't have an employment agreement or a collective bargaining agreement, by default, typically the employee is at will, and the question is just whether there has been discriminatory action or retaliatory action in terminating them. So I don't necessarily always think probationary periods are really that necessary from a disciplinary standpoint for at-will employees. They should just be as equally removable during their probationary period as afterward. But if you have a policy that somehow says otherwise, you would presumably want to be careful to abide by your policy or have a good reason not to. That's all the questions I see that I've received so far. I will give you another minute or two to type something in. In the meantime, for those of you who are logging off, I appreciate you taking the time. Look forward to seeing you at future webinars. If you have a question and haven't had a chance to write it all out, you can go ahead and enter the portion that you have just so I can tell if there's a question yet forthcoming. All right, so I'm not seeing anything coming in. I appreciate quite a number of you who have stayed on for the full time up to this point. Hopefully it's been helpful and informative. Obviously, there's always more to know on any topic and more I could say, but glad to provide this opportunity to give you a chance to think about these things, and hopefully you've picked up at least a few pointers along the way that you might not have remembered or otherwise thought of in making these termination actions. All right, so I'm going to go ahead and sign off. If you have any more questions after the fact, my contact information is on the slide, and you will get an email tomorrow, as I said, with all of this information for you as well.